You are the Tanya Harding of securities regulation.
Suppose I were to purchase a Pokemon card.
This is not supposed to be hard.
Does an investment contract require a contract?
It's not my identical twin brother, Rob, or anything. It's me.
Were you aware of the fact that the Hillary Clinton campaign actually paid for the Steele dossier?
4 o'clock Eastern Time is 1 p.m. Pacific Time. So,
Mr. Chairman, I really liked your colorful testimony. And you're right, we are blessed with the largest, most sophisticated, most innovative capital markets in the world. But we cannot take this for granted. Even a gold medalist must keep training. With all due respect, Mr. Chairman, if the U.S. capital markets are a gold medalist, you are the Tanya Harding of securities regulation because you are kneecapping the U.S. capital markets with the avalanche of red tape coming out of your commission.
Suppose I were to purchase a Pokemon card. Would doing so constitute a security transaction?
You could purchase a Pokemon card. I don't know what the context is, but if you're just purchasing a Pokemon card...
If I purchase a Pokemon card, is that a security
retail
transaction?
Store, that's not a security.
Okay. If I were to purchase a tokenized Pokemon card on a digital exchange via a blockchain, is that a security transaction?
I'd have to know more.
Okay. So for you, the process of tokenization is what transforms a non-security transaction into a security transaction?
Look, if the investing
I thought you were
public-
technology neutral.
If the investing public is anticipating profits based upon the efforts of others and they're exchanging funds, that's the core.
I see my time has expired, so.
Your view on Bitcoin, you've made comments on this. You believe Bitcoin is not a security. Is that true?
Well, I think the staff of the SEC have also, and the prior
Well,
chair.
I'm just asking you this question, and this is not a gotcha. I thought there's going to be an easy softball into harder questions. Do you think Bitcoin is a security?
No, I think I've said this in the past that I think that it doesn't
I'm asking you
meet the
to
Howey
answer
test.
my question now. This is not supposed to be hard.
I know. I said it
Just
does
to
not
answer-
meet the Howey test, which is the
Okay.
law of the land about being an
So
investment
it doesn't meet the
contract
Howey
and
test.
security.
So therefore, it's a commodity. Is that fair?
I would say it's not a security, and then the test is otherwise for other
Okay.
laws.
A couple times you've said the SEC's rulemaking, you're just kind of simply doing what Congress has asked for. Do you think that's consistent? I mean, there's 40-some rule proposals, and I don't know that Congress had asked for all of those. So how are you measuring that right now?
No, you raise a good point. It's not that you asked for it last week or last month, but our laws embodied by Congress are on the books, and we need, I think, really to say competitive in the world, to update our rule books to make sure that the markets, the Wall Street broker-dealers, the exchanges, the investment advisors, that they're working on behalf of your constituents, the investors, and the people with good ideas who want to raise money.
Do you remember where we left off, you and I?
I do. You're a very good questioner, sir.
All right, well, let me
Remember
refresh. Let's bring some things up. Where we left off was, did you facilitate the payment for the Steele dossier for the Hillary Clinton campaign back in 2016? Because you were the CFO. You acknowledged that. You also said, in response to my question, that this payment was not something that I was aware of, quote unquote. Those are your words. Interesting things have occurred since then. John Podesta actually testified to a committee of Congress, and John Podesta testified to a question about, was Gary, meaning you, was he day-to-day, hands-on, signing every check? And so John Podesta testifies, actually he was under a deposition with the committee here in Congress. He says, yes, I don't know if he signed the checks, but he was there every day, meaning you. So let's circle back. Were you aware of the fact that the Hillary Clinton campaign actually paid for the Steele dossier, which unleashed one of the worst issues of intelligence malfeasance that our nation has ever seen?
No, sir, I answered this 6 months ago, and this is the same answer today. No.
You weren't aware of what was going on? Mr. Gensler, I find that very interesting because, if I listen to some of the people and the staff that have left the SEC, you're very aware of everything that is going on. It's actually your MO. You're very hands-on. So you're going to tell the committee right now you had no idea that the Hillary Clinton campaign, of which you were the CFO on, sent money to Perkins Coie for a dossier that was phony, that led to the spying of a presidential campaign in 2016. You were not aware of any of this.
Look, sir, as a chief financial officer in a political campaign, I was not aware of what a law firm was doing with some of the monies that they got.
Now, I find that interesting because in some of your other rhetoric about CFOs in the public sector, the private sector of our economy, you are very tough on CFOs. You've said on the record on many occasions that CFOs have a fiduciary responsibility to the organizations that they cover, that they should be aware of everything that is going on. So how is that a standard you hold CFOs in the private sector to, but you don't hold yourself to that same standard?
That's not a standard that the SEC holds CFOs to. It's about their financials and that the financials are put together in accordance with GAAP and that the numbers are accurate. And that they're
So did you accurately pay for the
material
Steele
regards.
dossier out of the Hillary Clinton campaign?
Sir, I learned about that way after President Trump was a president and Hillary Clinton was a private citizen.
We know that an investment contract requires an investment. Does an investment contract require a contract?
You know, something about this definition, I will quote Thurgood Marshall, Congress painted with a broad brush. And when Marshall said that, he was writing the law of the land. So we follow this Howey test and how not just Marshall, but other courts interpreted it. And it has a four components.
I did not go to MIT, but in the Bronx, if I ask whether an investment contract includes a contract, the answer is typically yes or no. So,
Actually, sir, under the Supreme Court law of the land, they do not write that in.
would you please cite a decision of the Supreme Court that has found an investment contract in the absence of an actual contract?
The SEC has been in front of multiple courts, and investment contract has been.
What's the name of the case, Mr. Gensler? The Supreme Court case that has found an investment contract in the absence of an actual contract. Do you have the name? Can you cite a case?
The SEC over the decades, whether it's
Can you cite a
chinchillas,
case?
whether it's whiskey caskets, whether it's crypto, if the public is investing based upon the efforts of others.
I find it telling that you cannot cite a single case.
That's a security.
Not a single. How about a Second Circuit case? Can you cite a single Second Circuit case
I
that found an investment contract in the absence of a
I
contract?
understand where you're trying to go, and I'm going to leave that to the very fine attorneys at the SEC in front of courts. But I'm saying the core principle
Mr. Gensler,
is, this is a field.
This is. Let me finish. This is a question to which you should know the answer, because the definition of an investment contract is the central issue. That's what determines the extent of your authority. That's what determines the applicability of federal securities law to crypto transactions. And your inability to answer that question is baffling to me.
I'm answering it consistent with what the Supreme Court has said, which is the law of the land is a four-part test.
And yet you cannot cite a single case to support your argument.
Howey, it's called Reeves, it's called many cases at the Supreme Court, sir.
Are you familiar with metamaterials?
Yes, I am, sir. Not very deeply, but it is a company that I've heard of.
Do you know what the aggregate shares are, audited shares count of MMTLP is as of close of market on December 8th, 22?
I don't know. I know that it's a company that then exchanged into something called NextBridge, I believe.
Okay. Does SEC have this information on the audited shares?
It may be a matter of public record. I mean, it was a company that it did an exchange and became another company.
We'll try writing you another letter, and if you would look into it, we would appreciate that.
Do you believe the vast majority of digital assets meet the investment contract test and are therefore securities operating illegally outside of the U.S. regulatory umbrella?
As I've said, many of these assets are basically the public is anticipating
Sir, is
profits
that a yes?
based on the efforts of others.
Is the answer then yes?
Again, without prejudging anyone, I do think that the significant
Reclaiming my
majority
time.
are
I'll take it as a
investment
yes.
contracts.
And to be clear, sir, this perspective has nothing to do with a concern you noted in a speech last year where you said, quote, "Over the past year, several bank executives have shared their concerns with me about the sheer number of depositors who have moved money from their bank accounts into crypto-related exchanges and wallets," end quote. Right?
The concern that those bank executives raised was that
I'm reclaiming my time,
customers were
sir.
getting
No,
hurt. in
I've
the
asked you to
market.
answer the questions as short as I can so I can use the time I have, and it's clear that you would like to avoid answering the questions, in my opinion. Mr. Gensler, can you assure this committee that your style of regulation by harassment towards digital asset innovation is to the benefit of every American and not driven by your desires to protect industry incumbents?
This is a field that's rife with fraud and manipulation, and I'm looking out for the American investors who've been hurt by the crypto.
Again, I'll reclaim
fraudsters
my
and
time. Mr.
scammers.
Gensler, despite your years of rhetoric, like today, I'm convinced you are not an impartial regulator. Instead, it's clear that you are working to consolidate your own power, even though it means crushing opportunities for everyday Americans and, frankly, the financial future of this country. Even the federal courts are highlighting the damage you, sir, are doing to our constituents, and they're telling you that you don't have the legal authority to accomplish your goal of squashing competition in the financial markets. Congress has been telling you that too.
I'm confused. At which Gary Gensler, the American public, should believe? The academic version, who spoke glowingly about the power of technology to help more investors participate in U.S. and global capital markets, or the SEC version, who apparently thinks all use of any technology by broker-dealers and investment advisors is inherently conflicted, and firms should just stop using technology altogether. Chair Gensler, could you please briefly explain this change in your views?
I thank you for the question, a clever question. It's the same Gary Gensler. It's not my identical twin brother, Rob, or anything. It's me. And I believe technology is so transformative. I think artificial intelligence, machine learning is so transforming this decade and so forth. I think robo-advisors and brokerage apps, whether they're using these new technologies or some of the older predictive data analytics, just stand by that basic concept that the investor is first, not the investment advisor is first. That's all.
We agree there, and this proposal fails to acknowledge the already existing and well-functioning SEC regulations, such as Regulation Best Interest, Reg BI, and the fiduciary standard that protects investors.
How would the hard close proposal level the playing field for my constituents in Southern California when you're proposing a hard close at 4 p.m. in Eastern Time? It is 1 p.m. Pacific Time. So could you answer that?
So again, what we're trying to address is to ensure that when somebody redeems from a mutual fund, they don't leave everybody else in that mutual fund with losses or what's called dilution. I would say, given the clock, right now, anybody in your district already has to put their redemption order in it at 1 o'clock.
Right.
We're not changing that.
Let me reclaim, and I want to tell you that I'm specifically talking about my constituents being put at a competitive disadvantage compared to someone operating Eastern time. So you don't believe that a fund or an investor in California would be put at a disadvantage when they have to stop trading at 1 p.m. Pacific time, whether it's mutual funds or whatever that you're talking about?
I'm just observing currently, because the New York Stock Exchange and the stock exchange is closed by 4 East Coast time, and mutual funds redemptions are by 4 o'clock. That's currently, we're not changing that. That's already existing.
Again, 4 o'clock Eastern time is 1 p.m. Pacific time. So in my home state of California, obviously, we are very concerned about this, okay? Because we have to stop trading at 1 p.m.